You're watching The Legal Breakdown. Glenn, we are suddenly faced with what may be the October surprise to end all October surprises against Donald Trump in his D.C. trial. Can you explain what the update is here?
Brian, this is huge. Something that Judge Chutkan just dropped on the public docket indicates that we, the people, the American voters, might get to see all of the evidence of Donald Trump's January 6 crimes revealed in October, specifically on or around October 1st and on or around October 10th. I'll talk about why there are two dates in just a minute, but you refer to it understandably as an October surprise. And yes, in one sense, this may be the biggest October surprise in American history, but it's not the traditional October surprise. Why do I say that? Because October surprise really connotes a political revelation, right? Where one candidate or one party or one PAC reveals something devastating about the other candidate, hoping that it's so close in time to the November election that it's just going to sink that candidate or have a huge impact on the election. This has the potential to have a huge impact on the election, but it is not a political October surprise. Here's what it is. It is the legal system operating exactly the way the legal system is supposed to operate, without regard to any political election cycle or upcoming election date. And Judge Chutkan has said that multiple times in the strongest possible terms. Nothing in her case or in the schedule she sets will have anything to do with the upcoming election. But the reason these revelations are coming in October, it looks like, is because Donald Trump was given what he asked for. He ran to the Supreme Court saying, you know what? Sure, I may have committed a whole lot of January 6 crimes to try to unlawfully retain the power of the presidency, but I want complete immunity for it. Went up to the Supreme Court. The Supreme Court said, no, we'll give you some immunity. We don't know how much immunity, but what we are doing is we're going to give your case back to the trial court judge, Judge Tanya Chutkan, and we are directing her to litigate the question of exactly what you did, what the facts show, what the witnesses testified to, what the documents will prove. That needs to be litigated, and then Judge Chutkan can make her decision about what was an official act, what was not an official act, what should you have immunity for, what should you not have immunity for, and then we'll move forward in the litigation from there. Donald Trump asked for that, begged for that, and he got it. And now that Judge Chutkan has the case back, Jack Smith said, okay, Judge, we need to abide by what the Supreme Court just told us all to do. So we want to reveal all of the evidence of Donald Trump's crimes so you can go about making that all-important determination. And a briefing schedule was set. And now the brief has been filed. And now Jack Smith has filed his mega brief. There's a big old brief of about 180 pages, and then there's a whole bunch of attachments to the brief. And he delivered it all to Judge Chutkan yesterday and said, Judge, we want to file it under seal because we have some proposed redactions, some things we think should be blacked out because they're unduly sensitive, or witnesses might get hurt, or it might involve some classified information. So we're going to give it all to you, Judge Chutkan, with proposed redactions, and then you will tell the defense what you want from them regarding their position on these redactions that we've made. And then, Judge, you can release these documents publicly whenever you think the time is right. So what she just did, Brian, that was a very long run-up to what we just learned, which is that the judge issued an order. It's called a minute order. You just kind of put it on the public docket so everybody can read it. And here's what she said. I'm in receipt of all of the materials Jack Smith just filed. Here is the deadline I'm setting for Donald Trump's lawyers. By October 1st, just a few days from now, I want Donald Trump's objections to the motion, to the 180-page brief, any of the redactions that Jack Smith made in those. And then on October 10th, I want the second set of objections to anything that Jack Smith redacted from the attachments, right? The grand jury transcripts, the FBI 302 write-ups of witness interviews, the documents, the evidence. And when you give me your objections on October 1st and October 10th, I will rule on them. I will decide if the redactions are appropriate, and then, inferentially, I will drop it all on the public docket. So here is the open question, Brian. It looks like we have 2 dates. So if she resolves the objections to the release of the motion on October 1st, we could see
that's the 180 pages.
Bingo. And the attachments are all of the evidence that supports the facts that are laid out in the 180 pages, right? So if in the 180 pages it says, well, a Republican witness came into the grand jury and said he saw Donald Trump do X, Y, and Z and say A, B, and C. So that's the factual assertion or proffer. And then you look at the documents and the grand jury transcripts and the FBI write-ups that are the attachments to see the backup, the support, the evidence for that proffer in the motion. So listen, the motion is frankly what's most important, and all of the attachments are just the evidence that supports what Jack Smith said in the motion. October 1st is the deadline for Donald Trump to object to what's going to be released in the motion. So, Brian, we could see that motion on October 2nd. And then the second deadline, October 10th, is for all that batch of supporting information that's in the attachments. We could see that by presumably October 11th, because they have until October 10th to object to that. Is this an October surprise? Well, in the strict sense of that term, oh, heck yeah, it is. I mean, at this point, it feels like we're binge watching a Netflix thriller series and we're about on that last episode. But it is not a political October surprise. It's surprising and it's coming in October, but Brian, it is courtesy of the operation of the criminal justice system working the way it should work in an apolitical fashion, in my opinion.
I have to ask this question, but is there anything that Donald Trump could do to delay the release of that tranche of documents that are going to be that are set to be released after October 1st?
How quickly do we think he'll file something urging the Supreme Court to put a stop to it? Of course, if it's not already filed and just waiting there. Here's the good news. There is no legal vehicle that allows for an appeal of this decision to the Supreme Court. Judges make these kind of timing and scheduling decisions 1,000 times a day in courts all across the country. Can you imagine if every one was appealable? You know, we would never accomplish anything. Nothing would ever be tried to a verdict. It's not appealable. Now, look at who we have sitting on the Supreme Court, the rot at the top, as I always refer to it, the radical right-wing 6-justice majority. Will they ignore the law and try to put a stop to it? My gut tells me no, but my gut has been wrong before, because I always assume that the Supreme Court will be honest brokers of the law, at least at some level. And some of the justices have proved me wrong. I don't think this one will be successfully appealed, but I do expect Donald Trump to try.
Now, Glenn, we may have the opportunity to see all of these documents if they get released by October 2nd, but when is the trial going to happen? When are these issues actually going to be litigated in front of Judge Chutkan in court?
I suspect we will know the minute Judge Chutkan rules on the October 1st and October 10th deadlines and litigation. And once the record is set and she has decided what will be revealed publicly, then she will set a litigating schedule, a motions hearing. That could be as early as the latter part of October. It could certainly come well after the election, but that is not a question that anybody can answer at this moment.
And does Donald Trump have to be present in court for any of these hearings?
He does. Listen, in civil cases, you don't have to attend your own trial. You often decline to attend at your own peril because, the jury's like, I guess he or she is not interested enough in their own trial to attend. Criminal trials, you always must attend every single session unless the court grants a waiver, grants you permission not to attend. And courts have done that, even in criminal cases. Why? Because when a former president attends a court hearing, the courthouse has to basically shut down to all other business. Blocks and blocks around the courthouse get bogged down in, the necessary security when a president or former president arrives. So I suspect, particularly if it comes after the election that Donald Trump loses, you can bet Judge Chutkan will not likely waive Donald Trump's appearance. So he's going to be sitting his butt in a hard wooden chair at defense counsel table from 9:30 till 4:45 every day while this litigation progresses.
Do you presume that for these earlier hearings in the lead up to the election that Donald Trump will be able to have his appearance waived?
Open question. I'm going to say this is what I always say when I try to hedge my bets and I'm uncertain about what will happen. 51% of me believes that Judge Chutkan, once Donald Trump loses the election, and frankly, maybe even if he wins the election, but certainly if he loses the election, he will be required to attend. Judge Chutkan will not permit him to waive his appearance, to waive his presence. And I say 51% of me because it is always important to have a defendant present at every minute of his criminal trial or pretrial motions, because if they're not there and the defense attorney is confronted with all sorts of novel situations and has to make legal decisions on the fly, you know what a defendant will argue later on? Ineffective assistance of counsel because I wasn't there to be involved in these weighty decisions in my defense. Usually appellate courts won't buy it, but that's one of the reasons a defendant is almost always required to be present during every single minute of his trial and pretrial litigation.
Okay, and let's finish off with this. Glenn, we are just a few days out from October 1st. So is there anything that Donald Trump and his team could do in the interim, these few days between where we are right now, September 27th, and October 1st, that could prevent this schedule from being abided by?
The answer is no, under the existing criminal rules of procedure and criminal law. No right to appeal this decision, so there really is no ability to, for example, quickly file something in the first line of appeals court. That would be the Federal District Court of Appeals for the District of Columbia, which would be the first stop. He wouldn't be allowed to file anything right up to the Supreme Court, regardless of whether the issue was appealable or not. So does he have any legitimate vehicle to put a stop to it? No. Does that mean he won't try to file all kind of harebrained emergency motions and petitions for writs to put a stop to it? I suspect he will, and I think they will all fail.
Okay, well, things are very quickly heating up here in Donald Trump's D.C. trial, so we will, of course, stay on top of this. For those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.